America has dealt with many controversies over the years, but one that seems to withstand the test of time is the topic on whether or not abortion should be legal in the United States. In order to understand exactly how the United States views abortion, I would like to go over the history of it. So, according to the Chicago Tribune's History of Abortion in America timeline, in 1821 is when America's first statutory abortion regulation was enacted in Connecticut, and this was put in place in order to provide protection for women who are in their fourth month of pregnancy. So basically, after those first 4 months, you can no longer get an abortion. In 1856, however, pro-life advocate Dr. Horacio Storer established a national drive to end the legal abortion, but unfortunately his efforts failed, and everything was quiet until 1873 when the Comstock Act was enacted. This act basically states that information about abortion, birth control, they're all banned. Can't read them. And then in 1890, the American Medical Association, or AMA, tried to regulate abortions to meet certain statutes. And that statute is that an abortion is permitted upon co-reatal of one or more physicians. So basically, if you wanted to get an abortion, you would have to have the referral of two physicians, and it could only be in order to save the mother's life. In 1961, a phenomenon swept over Europe, and this was the vacuum aspiration style abortion, and that's what is still most commonly practiced today. It seems to be a safer route than previous abortion methods. In 1963, the Society for Abortion is established in San Francisco, and this group challenges the law by openly advocating for abortions. In 1967, abortion is classified as a felony in 49 states, and Dr. Leon Blois is convicted of referring a woman to a illegal abortionist. In this case, she was basically treated in the backseat of a car because she couldn't afford a legal abortion. In 1970, Hawaii becomes the first state to allow abortions to be performed before your 20-week mark of conception, and New York followed shortly afterwards. In 1970, Dr. James Hochsland is convicted in Minnesota for performing an abortion on a 23-year-old lady, but the judge did not send this to Supreme Court, instead found her guilty. In 1971, the Comstock Act was repealed, and people now had more access to information about legal abortions. And in 1973, we had a huge turning point for the abortions. We had Roe v. Wade, and this is a case where a woman named Norman McCorvey challenged the Texas law to make it a crime for doctors to perform an abortion on women unless a life is at risk. Now, you don't hear it's McCorvey v. Wade. She decided that she wanted, for her own privacy, to change her name, and she applied to go to court as Jane Roe, which is where we get Roe v. Wade. So the Supreme Court rules that women have the right to terminate pregnancies through abortion based on their rights of privacy. So essentially, it is the woman's body, and it is her choice as to what she does with it and whether or not she goes through with the full abortion. In 1976, the Congress passed the Hyde Amendment, and this bans the use of Medicaid and federal funds for abortions. In 1981, you have Bellotti versus Biard, and this is a case where the Supreme Court ruled that pregnant women can petition the court for permission to have an abortion without a parent's permission. This is mostly aiming for younger children, like rape victims. In 1989, you had Webster versus the Reproductive Health Services, and this was where we get the famous statement that life begins at conception. In 1922, you had Planned Parenthood versus Casey, which reaffirmed Roe v. Wade, holding that states may not ban abortions or interfere with a woman's right to one. In between 1992 and 1995, there was a lot of violence, a lot of shootings at abortion clinics, a lot of bombings, threats. But in 1996, the abortion debate shifts to state bans on partial birth abortions. So this is late-term abortions, basically anything around the 20 to 24 week mark of your pregnancy. This is also known as the dilation and evacuation medical procedure, and the 104th Congress tries to pass this bill, but President Clinton vetoes it. And the reason why this topic is so big right now is, again, like I said, on September 21st, 2021, Texas Senate signed the Texas Heartbeat Act. And this act literally reads, a physician may not knowingly perform or induce an abortion on a pregnant woman if the physician detected a fetal heartbeat for the unborn child. And in this law, according to the literal Senate bill, it reads, a fetal heartbeat is a cardiac activity or the steady and repetitive rhythms of contraction of the fetal heart in the gestational sac. The gestational act is basically what gives the woman a first sign of pregnancy when you go in for an ultrasound. It's that sac that holds the baby, if that diagram makes any sense.